We now cross over live to a Polokwane Magistrate's Court where 5 men accused of murder of 2 businesswomen are at the Polokwane Magistrate's Court in Limpopo to hear whether they will be granted bail. The state alleges that Stanley Leshabane, the husband of one of the murdered women, hired his 4 co-accused to kill the 2 women last October.
From the outset, the court wishes to advise all the parties that the judgment is 20 pages long. The court is not going to read every sentence or all the pages into record. It will be typed and it will be handed to all the relevant parties on Friday. If the family or any member of the public wishes to read the full judgment, it will be available from the prosecution. This was an opposed Schedule 6 bail application as determined in Section 60, subsection 11A of Act 51 of 1977, which determines the following. Notwithstanding any provision of this Act where an accused is charged with an offence referred to in Schedule 6, the court shall order that the accused be detained in custody until he is dealt with in accordance with the law. Unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit his release. All the applicants were arrested on the 23rd of October 2020 and charged with the following counts. Count 1, conspiracy to commit murder relating to the death of Makoena-Leshabane. Count 2, murder of Makoena-Leshabane. And 3, murder of Tebogo Mphuti. Tebogo Mphuti.
And then Tebogo, that's 23 October. They
All the applicants made affidavits, which is all summarized in the judgment, which I'm not going to repeat at this stage. It will be available, as I've said, to all the parties. As regards to the state witness, Colonel Tumisang Precious Sudumedi, who testified under oath and also handed in a Section 212 affidavit in terms of Act 51 of 1977, the court wishes to state the following. The Colonel assessed applicant 5 and wrote an extensive report. This court is not going to summarize the same. In conclusion, the Colonel stated that in her opinion, Mr. Leshabane's risk of suicide is medium to high.
Assessment number 5 or suicide or no. I am a friend of forest. When I look on a young team or a suicide.
The court wishes to state, to quote the following: considering his use of avoidance and minimization as coping strategies, which is referred to as constriction in personal construct theory, Mr. Leshabane is most likely to employ suicide as a constrictive method to escape or remove himself from a legal situation, which he possibly tightly anticipates, which is precise anticipation to threaten his identity as a reputable man in society, a good husband, and a loving father. As regards the aspect of applicants 5 desiring to commit suicide, the court has a report by Ms. Anna Almery Peterson, not an affidavit, and neither did she give evidence under oath to be tested, compared to Colonel Tumisang Precious Sudumadi, which was an affidavit, and the Colonel also testified under oath. As regards the evidentiary value of whether the applicant will commit suicide, this court favours Colonel Sudumedi's report. On page 98 of Bail, a Practitioner's Guide, 2nd edition, published in 2001, authored by John van den Berg, the learned author stated that due weight will be given to evidence which indicates that the accused contemplates suicide, for the accused's self-inflicted death will jeopardize the proper administration of justice as much as will be his abscondment. On page 17, the court has made a short conclusion. At the outset, the court must state that all the applicants handed in affidavits. This is a common way of applying for bail, but the court must take into consideration that the evidence cannot be tested via cross-examination.
And then
in contrast, all the state witnesses gave viva voce evidence, excluding the last state witness, Jacob Musamawale, who handed in an affidavit. The other witnesses were cross-examined and they are deemed to be strong witnesses in the eyes of the court. The onus was on the applicants to prove on a preponderance of probabilities that exceptional circumstances exist which entitles him to be released on bail. The applicants all testified that they were employed, had children, and that the state did not have a good case against them. That was the applicant's exceptional circumstances. In State versus Matabula, 2010, 1, SACR 55 SCA at paragraph 12, page 59, the Honourable Judge stated the following: but a state case supposed in advance to be frail may nevertheless sustain proof beyond a reasonable doubt when put to the test. In order successfully to challenge the merits of such a case in bail proceedings, an applicant needs to go further. He must prove on a balance of probabilities that he will be acquitted of the charge. None of the applicants in this matter has set up a prima facie case of the prosecution failing. It is the court's view that the applicants did not prove that the state's case is so weak that it can be deemed to be an exceptional circumstance. The state's case is set out previously in the court's judgment at great length. This court must accept accentuate the fact that it's not the court's duty herein to determine the guilt of the applicants, but rather to look at the evidence at this stage against the applicants.
But that's the current this is our proposal. As senior managing as a captain, woman at the long trial or Anita. Kana Gopi, Koto Iricia, what has been over Umanato or Aumana. Nasiska, what if I have been my figure issue, if their player was who fires, book in them, Garana, or it has developed as a fellow, Muki, you, Chakan, Catalogama.
As regards to the admissions and confessions made in a bail proceeding, it is taken into account to determine whether there is a bail risk.
Over the food, I'm admissions, confessions, I am
The evidentiary value is also taken into consideration, and it is common practice that if the co-accused implicates each other in the confession or admission, it is of value to the court to ascertain whether the state has a prima facie case and also whether it will be detrimental to give the applicants bail. The evidentiary value and the test whether the confession or admission was made freely and voluntary will be tested and decided by the trial court. In the decided case of Tebogo, Kobesi and the state, case number SA at R 34 of 2017, judgment delivered on the 23rd of February 2017, the Honourable Judge Malusi stated the following on page 5, paragraph 11. Section 60, subsection 11b of the Act requires that an applicant for bail adduce evidence which satisfies the court that exceptional circumstances exist which in the interest of justice permit his release. It is a twofold inquiry which places the onus on the applicants to satisfy the court on a balance of probabilities regarding A, the existence of exceptional circumstances, and B, such exceptional circumstances permit their release on bail in the interest of justice.
Statement or each evidence relatively strongly who so when I was more session, we cannot handle it. We can go back to the video for this handle in fact, no worry. What I do, I am trauma, some people, I am trauma, a territory has room. Who are not there, some civil has room, but they are very more cottage handle.
It is evident that the state has a prima facie case and the applicants did not prove any exceptional circumstances, and therefore applicant 1, 2, 3, 4 and 5, your bail is denied.
number 1, number 2, number 3, number 4, number 5, 6. I'm not part of the city and the
I suggest that we postpone the worship up until the next year.
I can't hear.
8 March,
30.
30 March.
Gentlemen, does it suit you? Three zero.
No, she can get another exam that in our court. I'm available on the 1st of April.
1st of April, Mr. Mphuti. The matter is postponed to the 1st of April 2021 for further investigations. You will all remain in custody. Yes, ma'am.
And the situation may proceed with our law for
Thank you.
Well, their judgment has been handed down in that bail application that has been brought by the 5 co-accused who are accused of murdering Makoena, Mabusela-Leshabane, businesswoman, and her business partner Tebogo Mphuti, who was 35 years old at the time, and the case has been remanded, meaning that they will be back in court, but they remain behind